Good morning, Judge.
Good morning. Ms. Onse, can you hear me? You may need to unmute yourself and turn on your camera if you can.
Good morning.
Good morning, Ms. Randall. Ms. Onse, can you hear me? Ms. Randall or Mr. Boyd, do you have a phone number for Ms. Onse so you can call her and see what the problem is?
Let's try again.
Oh, there we go. Can you hear me now?
Yes, I can. Are you able to hear us?
Yes. Well, I can hear you. I don't know who the rest of you are, but are you on a telephone or are you on your computer?
I'm on my computer, Your Honor. I was now it says it's unable to. Oh, okay.
Click on. It should be go to the top of your screen, and there should be a camera, and you need to turn on the camera.
It says it's unable to detect the camera. This is weird. It's saying it's unable to detect camera. Is the camera plugged in?
Well, as long as you can hear me, I guess we don't need to see each other. But
Well, we'll get it here in a moment. Does it have a? Yeah, where does it? It's in?
It's in.
Okay, let's give it a try now. Keep saying it's unable to detect the camera.
okay.
You are kidding me. Why is it in? Okay.
Well, if you're comfortable, let's just proceed on. And now I'm not sure that we're there because when I start talking, then I get the green screen and you disappear. So say something again so we can make sure you can still hear me.
Yes, we're here, Your Honor.
All right.
This meeting is being recorded.
Are you ready to proceed?
Your Honor, the State Ethics Commission is ready.
All right. Are you going to be arguing these motions?
I will, Your Honor.
All right. But before we get to the hearing on the motions, let's talk about our hearing date, which is April 2nd and 4th. Are those dates still good for the intervener?
No. Oh, go ahead, Mr. Boyd.
Sorry, Judge. Ms. Randall will be handling the motions for summary judgment, but I wanted to just flag a couple issues with the hearing date. We're not, the parties haven't stipulated to the use of deposition testimony for any of the witnesses who would likely need to testify at the hearing. And so we'll need to subpoena these witnesses. And in the course of preparing, we've realized that there's some timing issues. The commission won't meet until April 5th. That's the next commission meeting. And under the State Ethics Commission Act and the NMAC rules governing hearing subpoenas, we need to obtain leave from the commission before we can file something with the district court judge, Judge Hunter, and then get subpoenas issued and served. And so if the hearing is we would request a continuance that would give us enough time to get witnesses served with subpoenas to command their appearance at the hearing.
Any objection, Ms. Alonso?
No, we're fine with that.
Okay, well, we'll talk about a new date here in a second, but what's the issue with depositions? You aren't able to agree on any deposition testimony?
Well, I'll let Ms. Hans articulate her position, but I emailed her last week asking to see if she'd be willing to stipulate that, all the witnesses who gave deposition testimony are unavailable for purposes of using their deposition testimony at the hearing in lieu of their live appearance. And my understanding is that Ms. Hans is not willing to enter that stipulation.
Is that correct, Ms. Hans?
Yeah, Sharon, I don't believe these people are unavailable.
Well, they don't have to be unavailable for you to stipulate. You can stipulate to them whether they're available or not. If you don't want to stipulate to them, well, I can force you to stipulate to them. That means we're going to have to subpoena them, and it's going to take longer and be more expense. But whatever you and your client want to do, we'll proceed accordingly.
Let me confer with my client momentarily. She is here. Okay. My client and I, we would still object to just using the depositions.
Okay. Well, then, Mr. Boyd, if you want to call witnesses that are available, you're going to have to subpoena them. If you are in a situation where one or more of the witnesses are not available, then you can submit the deposition testimony. So that's the best I could do for you at this time, I guess. But I'm going to ask, just so I get some idea and you all get some idea, how many witnesses are you anticipate calling, Mr. Boyd?
We would be, I think, calling at least 2 witnesses, not including the respondent. So we would be seeking the testimony of Mr. Alan Carter and Mr. Stephen Ness, and we have no problem getting those witnesses served with subpoenas, Your Honor. My understanding is that there needs to be service of a subpoena, and they need to not show up before we can get a determination of unavailability. And so, we'll get the subpoenas served. It's just that because the commission isn't meeting until April 5th, and we need to get the commission to vote to allow me to petition the district court, I'd be looking to have a hearing. I think the best time in terms of service and all that would be in the first 2 weeks of May.
All right.
That'll be the continuance I'm seeking.
Okay, Ms. Huntz, how many witnesses are you anticipating calling?
Your Honor, I believe you would have 3 or 4 witnesses.
Okay, are you comfortable disclosing who you're going to call?
Yes, we would call respondent and Ms. Crystal Mavis, as well as Mr. I believe it's David Raybold.
All right, that's 3.
That's
Sure.
3. I'm not sure of our 4th. I'm not sure.
Okay, well, we're gonna address that in a minute.
Yeah.
Okay, so we'll vacate the hearing, reschedule it for Well, we could do I've got a conflict on May 6th, but I could do it then I would need a day or so. We do it the 9th and 10th or the week of the 13th. Any preference, Mr. Boyd?
I'd prefer the week of the starting on the 13th Monday. I think that's cleanest.
Ms. Hans?
The week of the 13th also works for us.
Okay. Still sounds like we could do this in 2 days. So let's do Monday, May 13th and Tuesday, May 14th. All right. Now, we talked already about exchanging witness lists. You've sort of done that, but I want you to make a more formal exchange of witness list and exhibits. Let's do that by April 23rd. I'll give you a month, which should be way more time than you need. And then I'm going to want each side to provide me with 2 copies of your exhibits, one for me and one for Ms. Koenig, who will be attending the hearing with me in all likelihood. For those who have met Ms. Koenig, she's the other person on our Zoom meeting. So let's have you provide the exhibits by a week before the hearing on May 6th. I'll put all this in an order, but okay. Any other issues related to the scheduling of the hearing?
Your Honor, you'd like 2 copies of exhibits. You want those hand delivered to your Dropbox?
Yes, but no, I don't know. I want them delivered hard copies, and I can come by and pick them up if you don't have somebody who could drop them off at my mailbox.
Okay.
And I forgot, Ms. Huns, is your office here in Albuquerque?
Yes, Your Honor. I'm here in the Heights.
All right, well, sort of neighbors then. So you can either let me know they're available and I can stop by your office and pick them up, or you can drop them off. I have a mailbox at the UPS store in the shopping center at Tramway and Academy. That's where I get my mail.
Oh, okay. We can drop them off for you.
All right. Thank you. Okay, so now we've got our hearing dates and other deadlines established. Let's proceed with our hearing on these motions. And before we get started, let me ask counsel to state your appearance for the record.
Good morning, Your Honor. Jessica Randall on behalf of the General Counsel Intervenor State Ethics Commission.
Ms. Randall.
Elizabeth Hans on behalf of the respondent, Karen Bedonie for New Mexico. And my client is present with me here today.
Ms. Hans, Ms. Bedonie. All right, Ms. Randall, let's talk about the first motion for summary judgment. And then I'll let Hans give a response and I may ask some questions.
Okay, very good, Your Honor. Essentially what I understood at the previous status conference, Your Honor made clear that you didn't want us to sort of reiterate all the points that we already articulated and supplied at length in our first summary judgment motion. And so I hope to briefly just address to the court both the question of liability, but separately, should Your Honor be willing to grant these motions today, I'm prepared to discuss a penalty assessment. There's 2.
All right. Let me confirm what you just said. I have read these motions and the voluminous exhibits twice. So I'm pretty familiar with what you all submitted in writing. So if you just want to hit the highlights, And then I may have some questions of matters that you may or may not touch on during the presentation. So you may begin.
Very good, Your Honor. May I proceed?
Yes.
Your Honor, there's two main reasons why the campaign finance laws matter and why we're before the court today. In order to enforce contribution limits, they can't be enforced by anybody unless there's accurate reporting by the candidates of the contributions that are received by supporters. And second, the public has a right to know who's publishing ads in support of a candidacy for office, especially a gubernatorial elected office, which is the highest office in New Mexico, or frankly, any state. Through the duration of this motion practice, what occurred to me, Your Honor, is that although Mr. Kokinadis filed his complaint back in July 25th of 2022, and we've been going an ongoing litigation and investigation practice, it wasn't until Mr. Boyd, as general counsel, made a probable cause determination and requested the assignment of a hearing officer that Your Honor got involved in October of 2023. And so there's just been a lot of investigation and discovery in this matter from the onset. I would point out, Your Honor, that nothing in the record, nothing asserted by the respondent through the duration of this case, she doesn't say that the emails between Karen Bedonie at gmail.com to Sun Vista Outdoor is fabricated. She doesn't say that the text between herself and Stephen Ness aren't real. They don't say that the text messages between Crystal Mavis and Mr. Ness aren't real. They just are simply saying that they aren't liable nonetheless, despite what those emails and text messages say. Your Honor, I've created a quick PowerPoint presentation just to touch on a couple of slides, if I could share my screen.
All right.
Can you all see this?
There you go.
Okay, very good. So the worst that can happen to me is a fine. And that was a text message from Miss Karen Bedonie on July 28th, 2022 to Mr. Stephen Ness, which was only 3 days after the complaint was filed by Mr. Kokinadis. And I think that this is just sort of the best crystallization of the theme of this case, that Ms. Bedonie essentially willfully violated the Campaign Reporting Act and didn't care. I want us to back up, though, and I'll start.
Well, let me stop you right there. What's the relevance of something she said after the complaint had been filed?
Because she was in communication with Stephen Ness, Your Honor, who she denied having any coordinated expenditure with. She was she found it to be unconcerned and unbothered with the consequences or the importance of following the Campaign Reporting Act. So it certainly touches on the willfulness of the violation.
What's the significance of her contacting Mr. Ness or having communication with Mr. Ness after the complaint had been filed?
Because they discussed
Resulted in the complaint and not subsequent events.
Well, again, Your Honor, I'm touching both on the liability before the court, but also the willfulness and the bad faith, should Your Honor grant these motions of the respondent. So it's sort of a 2-in-1, but it also bolsters the fact that they'd been in regular communication with each other even after the complaint was filed. They were aware of the complaint. They were aware of their coordinated efforts together, or she was rather aware of her efforts with Mr. Ness and didn't care.
Okay.
So backing up, Your Honor, to the 9/11 dinner dance back in September of 2021, I want to just point out a couple of things of this flyer. This flyer was created by the Bedonie campaign. It contains the conspicuous "brought to you by the good people of Eastern New Mexico," which is a very similar disclaimer to the ones in the billboard advertisements. This was came up with by the Bedonie campaign. And the thing that I would point out is that in this case, in the second summary judgment motion, they don't deny that there was fundraising efforts at the campaign fundraiser. They simply denied that it was a campaign fundraiser, and they say, well, we were just invited there and we were told we could raise campaign monies, but it wasn't put on for our benefit. It wasn't put on in support of the campaign. And that's just simply unsupported by the record. Mr. Carter, who was a prominent dairy farmer in Eastern New Mexico, discovered Miss Bedonie, first saw her speak in Grady, New Mexico, a couple months prior to this event, and decided that he wanted to support her as a governor candidate in the Republican election primary. And he coordinated directly with Crystal Mavis in getting this thing off the ground. But the other thing that I would point out is they claim that they didn't know anything about putting together these this Clovis Civic Center campaign event and just showed up. But this flyer, which was created by the campaign, says dinner tables are now sold out. See y'all there. And the relevance of that is that this flyer was put out after all of the tables had been sold. Thus, the campaign, the Bedonie campaign, was fully informed and lock in step with the organization efforts, including the in-kind contributions with Will Bannister and Colby Carter. I understand Your Honor wanted me to focus on the first motion for summary judgment, but the PowerPoint presentation was chronological. So if it pleases the court, I'll move forward.
Okay, proceed.
Jumping forward to April 2nd, 2022, at Crystal Mavis, the campaign treasurer, which again, there's no dispute from the respondent that Ms. Mavis was in fact an agent of the campaign. And the law presumes that a candidate for office approves of contributions solicited on behalf of the campaign. Further, that agents are lawfully acting on behalf of the campaign. Ms. Mavis was understood, at least by Mr. Carter, as not only as the campaign treasurer, which she registered for, but also essentially a campaign manager. And so on April 2nd, 2022, Ms. Mavis texts Mr. Ness, providing him with the canva.com link and suggesting that they make a billboard, providing him thus several images, which later Ms. Bedonie posted to her Facebook page. It was approximately 50.
And let me interrupt you for a second.
Yes.
Is there any dispute that it was Mr. Ness who contacted Ms. Mavis rather than she initiating the contact between the two?
No, I don't think so, Your Honor. The conversation between Ms. Mavis and Mr. Ness, I would mention to the court that, we subpoenaed text messages between Ms. Mavis and Mr. Ness and Ms. Bedonie and Mr. Ness going back to January of 2022, but their interaction goes further than that. Mr. Ness first met Ms. Bedonie in 2021 when a friend of his recommended that, they get to know each other, that she is a good candidate for a Republican governor. And he was kind of, per his testimony in his deposition, he was sort of reluctant to meet her. He didn't want to get involved in politics. He had been sort of burned by politics and found them to be unuseful, but he agreed to speak with her. That conversation turned into a 2.5-hour conversation, and he decided that he thought she was great. That's when phone numbers were exchanged, including phone numbers between Ms. Mavis and Mr. Ness. But as far as initiating the suggestion at relevance here, the coordinated expenditure of the billboards, absolutely undisputed, as evidenced by the text messages. Ms. Mavis suggests to Mr. Ness the creation of a billboard. He did not solicit, he just says, I'm here to be a supporter. His support commenced collecting signatures. It was but for her suggestion that this occurred.
So you're saying basically Mr. Ness contacted Ms. Mavis and said, I want to help, what can I do? And it was Ms. Mavis who suggested the billboard. Is that what you're saying?
That's what the evidence is supporting and shows through the text messages. Yes, Judge.
All right.
And I'll go back and show that it was completely of her own. There's a separate conversation. Who's getting paid to do this? Who knows? Unprompted, unsolicited. We have an April 2nd, 2022 text message from Ms. Mavis on the screen with the canva.com design link that the Bedonie camp designed. It wasn't a grassroots supporter or a Navajo youth, as they've insisted. They designed the image and provided it to Mr. Ness and said, hey, this would be awesome if you could create a billboard. The subsequent slide, true to his word, you bet, I'll get it done. And it's at her suggestion, a billboard on I-40 would be awesome. He only responds after she says a billboard on I-40 would be awesome.
I'm sure you're going to get to this in a minute, but could you go back to that previous slide you had? That's what Ms. Mavis sent to Mr. Ness. Is that what you're saying?
Yes, Judge.
Does that image contain any disclaimer at the bottom? I can't tell from the screenshot.
And Your Honor, I will get to that in 2 slides, but this canva.com link provides 50 images, and those 50 images are identical to the ones that Ms. Bedonie posted on the April 10th to her Facebook page in their entirety. And they all say paid for by private persons of New Mexico. That disclaimer was created by the campaign.
That was my question. All right.
And I have a blown up image subsequently. So at Ms. Mavis's suggestion, a billboard on I-40 would be awesome. Mr. Ness, true to his word, says, you bet I'll get it done. She subsequently again provides him the same canva.com link and instructs him how to use it. Then, Your Honor, on May 27th, 2022.
Just ignore that phone ringing in the background.
All right, shall I proceed?
Yes.
On May 27th, 2022, Ms. Karen Bedonie provides Sun Vista Outdoor LLC with the graphics. Gayla Graham, Mr. Rabel testified in his deposition on February 4th, is his graphic designer. He's copied, as well as Ms. Mavis is copied from Ms. Bedonie. She says, we used a canva.com to design this image. We hope it's workable for you. It wasn't they designed it in her admission in this email, not some grassroots supporter. Not that that's particularly material. This is sort of icing on the cake. They're also coordinating and contributing to the creation of this billboard at this point. Signed, Team Bedonie. And here, Your Honor, as you asked before, is the graphic that was provided by Karen Bedonie at Gmail to Sun Vista Outdoor, containing the disclaimer at the bottom. Paid for by private persons of New Mexico.
All right.
Not a month later, on June 11th, Stephen Ness shares the final product of the billboard with Ms. Bedonie. Holy smokes, that's amazing, is her response. But more important is she thanks him and his family. She says, God bless you and your family. She knows exactly what his efforts were, and was a participant in the creation of this the entire time. She then immediately shares this billboard to her Facebook and gives a shout out, if you will, some recognition to Torrance County, knowing that was Stephen Ness and where he lives. The first comment on her Facebook page that day is from Miss Mavis, God bless the Patriots of Torrance County.
All right.
The following month, the I-25 billboard goes up just outside of Socorro, New Mexico on I-25. And I'd represent to the court, because this is the best image I could provide at this time, is it's identical billboard with the identical disclaimer, paid for by private persons of New Mexico. July 25th, Brett Kokinadis, colloquially referred to by the respondent and her campaign as Mr. Coconut, which I assure the court has relevance moving forward, files his complaint with the State Ethics Commission. On July 28th, Miss Mavis sends a billboard meme making fun of Mr. Kokinadis with using the billboard background. And of relevance, Your Honor, is that you just picked a fight with the people. Kokinadis, kiss our First Amendment ass. And the relevance to that, Your Honor, is again going back that the respondent in these motions for summary judgment doesn't dispute that the communications between Ms. Mavis and Mr. Ness are real. They don't dispute that the email from karenbedonie@gmail.com is real. They just don't think that they're responsible and that they have liability, that it's outside, that they have the First Amendment right that to post these without complying with the campaign finance laws require them to report who paid for these billboards in support of their candidacy.
Okay. I understand that. And from the information that's been provided, I know there's a little bit of history between Mr. Kokinadis and Ms. Bedonie, going back to when she was a candidate for the Republican nomination for the governor, and they had some discussions, including in Santa Fe, and Mr. Kokinadis said to somebody, I forget who, that he supported liked Ms. Bedonie, but she wasn't his first choice. Then later she dropped out of the Republican primary and began her own candidacy as an independent, and obviously that made Mr. Bedonie unhappy, one can assume, and so there's this tension back and forth between those two. but I still have a hard time finding that any of these subsequent comments that occurred after the complaint was filed are relevant, because the issue is whether or not the allegations in the complaint are established by facts and evidence, and if so, what should I do about it? So you can keep mentioning these things, but I'm here to tell you now, unless you can convince me otherwise, I'm not very interested in things that happened after the complaint was filed.
Understood, Your Honor. If that's the case, again, I think that the relevance of these images is the knowingly and the willfulness of the violations. It also just enforces, because, Your Honor, for example, when they filed their response to the complaint, they disingenuously claim that, it could have been Mr. Kokinadis who used the name private persons. So it's really about that the cover up is worse than the infraction itself, which really lends itself to a penalty assessment as much as a demonstration that Ms. Bedonie, even after being informed that there was a violation of the Campaign Reporting Act by failing to have the adequate disclaimer on the billboard, but also reporting those coordinated expenditures that she made, both for the dinner dance and these billboards, was unconcerned with attempting to comply or bring these violations into compliance, but instead wanted to sort of make a mockery of this proceeding. But I understand where Your Honor's position is.
Well,
and so
that's an interesting question. We may want to discuss it at the hearing, if we have a hearing, particularly as it relates to damages. But I think that Ms. Bedonie has a right to challenge the complaint, and she has a right, if she doesn't want to accept any offer that might have been made by the State Ethics Commission to resolve this dispute, she has a right to have a hearing. And whether or not all these extemporaneous comments are relevant, we'll leave for further determination.
Understood, Your Honor. I guess I would just mention again the public harm involved in the after the fact. But to your point, that's not directly touching to the suggestion, coordination, cooperation of the Bedonie campaign and Ms. Karen Bedonie herself with Stephen Ness in creation of these billboards. But it was certainly their disclaimer that they put on there. It was their responsibility to have the appropriate disclaimer that said paid for by Stephen Ness and approved by Karen Bedonie, and their failure to report those expenditures on their regular filings of campaign contributions and expenditures. So
let me ask you a question about that disclaimer. Is it enough? Let's say that I'm not convinced that the campaign through Ms. Bedonie or Ms. Mavis or anyone else initiated these billboards, but is it enough if they provided images on their website or on her Facebook page that had the disclaimer on it? Is the disclaimer itself something that's reportable?
yes, that's a separate violation. So, Your Honor, the elements of coordinated expenditure under 1926I of the Campaign Reporting Act is that it has to be by a person other than the candidate or campaign. Well, that's undisputed. Stephen Ness paid for the billboards. That's not in dispute whatsoever. Number two, at the request, suggestion, or in cooperation or consultation or concert. So, Your Honor, I don't think that the issue has to be completely foreclosed upon depending on whether who started the conversation, who initiated it, as Your Honor has asked. I don't think that that's what a coordinated expenditure requires. It requires that it has either is at the request or suggestion, which I think that the text messages I've just displayed demonstrate that, but also in cooperation, consultation, and concert, which could happen regardless of whoever initiated that discussion. And that's evidenced by the graphics being provided to Sun Vista Outdoor, that's supported by Ms. Bedonie posting those 50 images on her Facebook that she created and designed and then provided to Mr. Ness.
All right. I'm glad you brought this issue up, because I had been looking at the definition of coordinated expenditure from the Title I, Chapter 10, Part 13, general government administration, election, elected officials, campaign finance, and the definitions there. And then you in your briefing have cited the definition from section 1-19-26, H and I, H for contributions and I for coordinated expenses. They're basically the same. There's a little bit of a difference. But the question that I have is, in this language, I think is the same. The language that I'm a little troubled with is, and I'm going to read from 1.10.13.28a. A coordinated expenditure shall be treated as an in-kind contribution from the person who made the expenditure to the candidate or committee at whose request or suggestion or in cooperation, consultation, or concert with whom the expenditure was made. Now that leads me to believe that it may be important in establishing whose idea this was and who suggested it or who requested it. And we've sort of talked about that already. But here's my question. I mean, what if Mr. Ness has contacted his Bedonie's campaign and said, I want to support Ms. Bedonie and I want something that I can put up in my yard or put on the back of my truck or display in some way. Can you send me some materials so that I can make this? Doesn't have to be a billboard, it has to be a poster, something that shows support. Is that sufficient cooperation if the campaign merely says, here's some images that you can use, you can find them on my website, or you can find them on my Facebook page? Is that sufficient?
Yes, they sought images from the campaign that was approved by the campaign for the purposes of supporting the campaign. It wasn't a grassroots image that they drew themselves in support of, in cooperation with the campaign. It was provided to them. But more important, once Ms. Bedonie spent over $1,000 on advertising, it was her responsibility to make sure in supplying those graphics to the people who wanted to create those supporters, the appropriate disclaimer saying who paid for it and who approved it. But also, I would distinguish the difference between an independent expenditure and, as it's been defined in the NMAC, a coordinated expenditure. So this wasn't an independent expenditure, which we have dealt with in other situations. This is a coordinated effort. That's what Your Honor has just provided an example of.
So coordinated just by the mere fact that, well, what if somebody calls and says, can I stop by your campaign and get some yard signs? And the campaign gives yard signs and it has the same disclaimers. Is that enough to make the campaign responsible?
The yard signs need to have the appropriate disclaimer, but that's not cooperation or coordinating the construction of this billboard image like we have before you. Those would have already been created and spent money on and would have been reported by the campaign as funding spent in advertising that they could then hand out to supporters either in exchange for a contribution or...
Well, isn't that how these images that Mr. Ness provided were created by the campaign for purposes of advertising?
No, they didn't have yard signs and said, we have yard signs for $50 contribution. You can take one that we already designed and reported on our campaign reports of expenditures and contributions as advertising, which they did. That's what candidates do all the time. The issue here is that it was at Crystal Mavis's suggestion that they create this billboard and that it was created in concert with, in cooperation with the Bedonie campaign to get the thing created.
Okay, so you have two things here which you think was a violation. Number one, on its face, the images that were provided were improper because it had an improper disclaimer. And number two, it's your belief that the evidence has established that it was Ms. Mavis who suggested the billboards and then worked with Mr. Ness and ultimately Mr. Raybald. I don't remember whether he contacted Ms. Mavis directly, but it seems like he did, at least for the I-25 billboard.
They asked Mr. Ness to pay for it. That's the difference. If we're talking about the yard signs, then a campaign goes to a printing shop and says, I want 100 yard signs made. They pay for the cost of the yard signs and they report it to their campaign reports of expenditures and contributions as an expenditure of the campaign in advertising. In this instance, they solicited the support of a campaign supporter, Mr. Ness, to create and generate, at their suggestion and consultation, a billboard.
I don't think you've got me on the solicitation part, because I don't think they contacted him and said, well, you do this. He contacted them and said, it's something I can do to help. And then she said, billboards. Isn't that the way it went?
No, Your Honor, that isn't how it went, but I don't think that the issue turns on that. I respect that this is Your Honor's decision to make, but I would say that that's not what the evidence shows.
Okay, what does it show?
The evidence shows that at the suggestion of Ms. Mavis, a billboard on I-40 would be awesome if y'all could pool your money.
Okay, but he's the one who contacted them and said, I'm willing to help you. They didn't contact him and said, would you help us? Do you have and contribute some money? And here's how you can help us if you make a billboard for us. He just said, I want to help you. And then you say it was Ms. Mavis who suggested the billboard.
He said initially they asked him to get signatures in support of her campaign. And in January of 2022, he goes up to Santa Fe and, attends just moral support. He collected a handful of signatures before this point. And it was only at her suggestion did this billboard come to fruition.
Okay. All right. Move on. I think we've talked enough about that.
Understood, Your Honor. Well, Your Honor, if the facts subsequent to the filing of the complaint and Your Honor has made clear is not germane to our presentation, then I would just reiterate that the reasons I've stated, that they're not saying that the emails are fabricated. They aren't saying that the text messages aren't real between Mr. Ness and Ms. Bedonie. And there's no evidence that but for their suggestion and cooperation and collaboration with Mr. Ness and Sun Vista Outdoor would these billboards have been created. And for those reasons, we respectfully request that you grant summary judgment both on the billboard advertisings, but also on the 9/11 dance. Thank you.
Okay, so you sort of included your argument on the second motion.
I believe so, and I respect what the court is informing me as far as the additional information I had to present. That is all evidence subsequent to the filing of this complaint. So I'm not going to belabor it if Your Honor doesn't believe it to be relevant, except for should we revisit a penalty assessment. I'm prepared to do so today.
Well, I never want to discourage a lawyer from trying to persuade me that I'm wrong. So if you want to take another shot at it, you can, but I really don't see how that's relevant to the original charges.
Well, it demonstrates willfulness in an attempt to conceal their coordinated efforts. That's what's relevant about it, is that they knew that they collaborated and coordinated this expenditure, and deliberately, because it was an attempt to conceal and create this farce to the public, that it was a grassroots effort of its own momentum, that independently Mr. Ness created this billboard and put it on, I-40, whereas instead it was a coordinated effort on behalf of the campaign who asked Mr. Ness to put this billboard up, again, in furtherance of this idea that their campaign had so much momentum that, people were just so inspired by her campaign that they independently of a grassroots effort were putting them up, which is simply to the contrary. It was a coordinated, consulted with effort. That's the relevance of these additional slides, is that rather than, it wasn't an independent expenditure. It was a coordinated.
Okay, well, I don't know. I mean, some of this material that you've been talking about may have been included in what was attached as exhibits to the motions. I don't recall all of it. But what I do recall is that Mr. Ness sort of felt bad that he had created this whole situation. And so there may have been some commiserating after the fact, and who knows what led to who saying what, and don't worry, worst can happen to me is a fine. I really don't think that that's relevant in determining whether or not the initial events constituted a violation. So let me hear what Ms. Owens has to say.
Thank you, Your Honor. When we look at the PowerPoint presentation, the advertisement for the 9/11 dance and dinner, it's clear that Miss Bedonie is the special guest and that there's going to be music, and it's called the 9/11 United We Stand. Her daughters created that flyer that was posted on Facebook. I don't think that was the official flyer of the dance or whatever, unless they used it for some reason, but it was to let the Bedonie supporters know where she was going to be, and so they could come out and support her. And we've gone over that Ms. Bedonie as well as Ms. Mavis testified that Mr. Carter contacted them. They didn't mastermind this event. Mr. Carter contacted them to see if Ms. Bedonie would come and speak. And then it was Mr. Carter and his mother that were taking money for tables and paid the Civic Center. And then ultimately they had, I think, an overage, and they donated that overage to Miss Bedonie's campaign, which Miss Bedonie reported on her expenditures, that she had been given a donation from.
Well, isn't that the problem, Ms. Lindsay? If she reported the overture's expenditures, then how can you claim that the other in-kind contributions weren't campaign expenditures that should be reported?
Well,
you'd be inconsistent.
Well, because our position is there was no in-kind. They're saying that because the musicians liked Miss Bedonie, that they were giving an in-kind contribution, but Miss Bedonie had nothing to do with them. Mr. Carter testified that it was one of the people was his son, and he testified that he arranged for the music, and that Miss Bedonie was told that she could take donations, and what Mr. Carter decided to do was give a donation to the Bedonie campaign, and that donation was reported. But other than that, we don't believe Miss Bedonie had a duty to report an in-kind contribution for that dinner. The dinner was being held because of the lockdowns, and the people in eastern New Mexico were sort of defying that by having this dinner, not wearing masks and having a dinner and a dance. And that was the motivation for the 9/11 and also the 9/11 anniversary. And,
I understand that there's a patriotic event from their perspective, but the fact of the matter is that Ms. Bedonie benefited from it, and she reported some of the benefit, but not all of it. And I don't think that's consistent. Go ahead. Let's talk about.
Okay. Well, I'm not sure what in-kind contribution did she not report. I'm not. The singers.
All of the two musicians and the cost of the event.
Well, it wasn't her event. She was a special guest there, but it was not her event. It was Mr. Carter and there were several other ranching families that put this together, and then they contacted Miss Bedonie to come and speak. So that is our position.
Were you listening when Ms. Miranda and I read the definition of coordinated contribution?
Yes.
Isn't that coordinated contributions? They're working with Mr. Carter to have this event, and they're going to benefit from it. They did benefit from it. They reported some of the proceeds, but not all of them.
If Ms. Bedonie is just a guest, how can she have any control over the expenditures of Mr. Carter and his decisions.
I understand your position, and if you need me to decide whether or not she was a guest, I don't think that's going to get you over the hump. But I understand that's your position, that she was a guest. And she was just there, and these people gave money, and wasn't her idea. But I'm not sure that's supported by the evidence that I've seen so far. Let's talk about the first motion.
Okay. The first motion, the billboards. First of all, Ms. Mavis didn't suggest the making of the billboard. I believe Mr. Ness in his deposition testified that he wanted to support Miss Bedonie and he wanted to put up billboards. He contacts Ms. Mavis, who then provides him with images. The Bedonie campaign did not choose the image that was used, did not choose the location where to put it. They simply provided images like they did to hundreds of other people to make yard signs or banners. And Miss Mavis testified that Mr. Ness was a farmer in Torrance County. She thought maybe he had frontage property, and that is he putting this up on private property? That's what she thought, because there were people that contacted her from Las Vegas who had sent off to, like, I think it was Vistaprint or something, to, once they got the image, to make banners to put on their walls or their fences. And so that's what she did, was provide the images. And when he told her about that there was going to be one on I-25, she was excited about that. And they were trying to get the size to fit. But it wasn't, and Miss Bedonie has testified, it wasn't an image that she would have chosen for herself. She didn't pick the image, Ness did. Ness contracted with Mr. Raybould. That's uncontroverted. And Mr. Raybould says that he never spoke with Miss Bedonie about it.
Let me interrupt you for a second to get something clarified. Ms. Mavis was clearly working for the campaign, on behalf of the campaign. Ms. Bedonie sort of describes her as the person who was responsible for reporting all the contributions and expenditures, which sounds to me like she was acting as a treasurer. Did Ms. Mavis have an actual title as far as the campaign was concerned?
Her title was treasurer.
She was a treasurer. All right.
She was listed
no question,
as treasurer.
No question that Ms. Mavis had authorization to act on behalf of the campaign.
Yes, she did.
All right. Now, somewhere in the material that's been submitted, it may have been Ms. Bedonie who testified to this, that only she, and then she later said her daughters, had access to this email address that was being used. Is that your position?
Yes, Your Honor, and the particular email that Miss Randall references, where it says Team Bedonie, that would have been done by her daughters. And
how many daughters did Miss Bedonie have?
5.
How many of them worked on the campaign?
3.
Okay, and one of them, the only one I've heard referenced in connection with some email that Ms. Bedonie was asked about, and she said that was, I think it's the one you just referenced, but she said that was sent out by my daughter. She thought it was Paisley, as I recall, and Paisley is, as I understand, was 13 years old at the time.
Yeah.
Is that correct?
Yes.
How old were the other 2 daughters that worked on the campaign?
Abby was 19.
Abby was 19.
And Laura was 20.
And Laura was 20.
Okay. So Abby and Laura are adults. But let me ask Ms. Randall a question here. Can Ms. Bedonie and the campaign be held responsible for something that Ms. Bedonie's 13-year-old daughter may have done?
Absolutely. It was acting on behalf of the campaign as agents of the campaign.
Even though she's a minor?
It's the email listed for KarenBedonie@gmail. It's the official email of the campaign. Whether they delegate that to a child or an adult is a decision on behalf of the campaign, and ultimately the responsibility impugns to the candidate.
Okay. All right, Ms. Huntz, what is your understanding of when, if ever, did Ms. Bedonie have any direct communication with Mr. Ness, either in person, telephonically, text, email, or Facebook, any kind of communication?
When did the first time she met Mr. Ness, it was when she was still a Republican, and they took her out to Ness Farms to make a speech. She believes that she said hello to him at that time, but she didn't realize that it was Mr. Ness at the time. Later on, she had evidently the text message communications with him, but the messages, it's misleading in a way that Mr. Ness puts the names, Karen Bedonie and himself, but Ms. Bedonie only had a phone number that was only tied to a phone number, and she dealt with hundreds and hundreds of people, and it's not, this isn't the only person that she would, and also her daughters would also answer certain things like, we'll be there soon, or that's great, or if it's, just to keep the group texts, because there were group texts sent to many, many people, not just Mr. Ness. So some of that was partially group text, some of it was specific conversation. And
well, what's his phone number? What's the significance of this phone number? Are you saying that Mr. Ness might have said something to the campaign email, and he may say Ms. Bedonie, but it was just sent to the email address for the campaign, and she wouldn't necessarily answer those herself? Is that what you're saying?
well, no, it would be the Facebook Messenger as well as the text messages. I guess I'm not sure if these are on Messenger or but it was for Ms. Bedonie. She did not connect a specific phone number with Mr. Ness. She's just answering a supporter on some of these.
Oh, so you're talking about a text where a phone number would show up and she's not sure whose number it is?
Right. She didn't put Mr. Ness there. It was just a phone number, and that was part of the problem. And this goes toward the whole thing about getting a fine. When I talked to Ms. Mavis and Ms. Bedonie, they indicated that Ms. Bedonie could find like one email. And I'm like, why are you not finding any emails? And it's Ms. Bedonie had an email that erased every 30 days. Ms. Mavis, once she read an email, she erased it. And I'm like, or deleted it. And that is where I told Ms. Bedonie, I said, I think that was improper. You should have kept everything, and they could give you a fine for that. That could be a violation. And so I think that's where, when she says the most they can give me is a fine, that was because of the emails, not for anything else. And it certainly wasn't, doesn't show a cover up or coordinated effort.
All right, let me ask you something more specific. I'm referring now to the first motion for summary judgment. In the undisputed facts, I'm going to read paragraphs 30, 31, and 32. 30 says, on May 26, 2022, David Raybould sent Stephen Nash the lease agreement for the billboard off I-40 in Torrance County. That references Mr. Ness's deposition. Number 31 says, on the same date, Mr. Raybould tried calling the respondent, but he could not reach her. Mr. Ness replied that he had spoken to the respondent the day before and would ask quote, Crystal to get in touch with Mr. Raybold, end of quote. That refers to Exhibit 9 C002. I'm not sure, it must be an exhibit to a deposition. Paragraph 33, on May 27th, 2022, the respondent emailed Sunvista Outdoor LLC with the image she wished to use for the Torrance County billboard. Again, that's Exhibit 6. It must be from Bedonie deposition. Do you dispute those facts?
Well, as to number 30, it is true that Mr. Raybold and Mr. Ness entered into a contract for the billboard on I-40. There was a Philip Clark that I guess contracted, even though Mr. Ness paid for that billboard. There was Philip Clark who contracted for the one on I-25. So yes, that's true that they did form a contract. And Mr. Raybold indicated that he believed his contract was between he and Mr. Ness. Then on number 31, I wrote down nobody got, okay, Miss.
Well, Mr. Ness says that he talked to the respondent the day before. Ms. Bedonie, in her answer, in her response to discovery requests, and I assume in her deposition testimony, said, I never talked to the guy.
Right. She never talked to Ness about a billboard and never, and I know Mr. Ness says that they did have conversations about a billboard, but he has no text messages where Ms. Bedonie has any knowledge of a billboard.
Well, do you dispute that Ms. Mavis talked to Mr. Ness and maybe Mr. Roybald about the billboard on I-25 or I-40?
I don't believe Crystal Mavis talked with Mr. Raybold. She may have, as we see in the text messages or the messages that she had communication with Mr. Ness as far as the image and giving the image out to him and being excited for what he told her, that we're going to have 2 billboards, and she's excited for that, but she isn't, quote, approving. She never approved the billboard because they never saw the billboard. There was an image taken. The billboards were made and put up by Mr. Ness, who Mr. Ness and his group of followers called themselves Private Persons of New Mexico. Precisely because they.
Let me stop you there because I want to ask you about that.
Okay.
Do you dispute that the billboard on I-25 and the billboard on I-40 were duplicates of I don't know if it's a screenshot from Facebook or it was something that was prepared by Kava, but you dispute that the images on those billboards came from the Bedonie campaign?
Yes, they did, because they came from a group of images that my client had received from Navajo youth or male youths who created them. But
right.
This group private.
Okay. That's what I.
Yeah. And she screenshot them.
Wait.
Okay.
Second question I have: do you dispute that on all those images that were provided, the disclaimer at the bottom says "brought to you by the citizens of New Mexico" or whatever the proper language is? I forgot. Private persons of New Mexico, something like that. Do you dispute that? And all those images, that was the disclaimer at the bottom.
And we don't dispute that. Those were screenshots that she posted, but she did not create. Ms. Bedonie had nothing to do with creating them.
Well, I'm not interested in who created it. I'm interested in that the campaign accepted them and the campaign distributed them to other people, right?
I believe so, but I'm imagining if the only people that put up that put up billboards were this group, Private Persons of New Mexico.
Well, what is your understanding? Okay, let me ask you this. You've already told me that these images that the campaign provided to Mr. Ness, or particularly the one that became the billboard on I-40, as I recall, and Mr. Carter later on, I'm sorry, not Mr. Carter, somebody else paid for the one on I-25. Those images came from the campaign, and those images had the disclaimer paid for by the citizens of New Mexico, whatever the language is.
Remotes that they added, took it apart and put it back.
Yeah, yeah.
So why do you keep saying that you don't, or more importantly, what is the relevance of who came up with that phrase, as long as the Bedonie campaign adopted it and used it on its campaign material?
Well, our position is that it wasn't adopted by them. They simply screenshot what had been sent to them and or what they had seen, and then posted it on the Facebook.
Okay. All right. Anything else?
Well, as to the group and Private Persons of New Mexico, Mr. Ness and a group of his friends who were Republicans called themselves Private Persons of New Mexico, and they're the ones that paid for this billboard. For some reason, the Ethics Commission hasn't sought to find out who the members of Private Persons of New Mexico are from Mr. Ness, but I believe the testimony of Mr. Ness, it's uncontroverted that he wanted to put up a billboard or billboards in support of Ms. Bedonie. He was a Republican and was a delegate to the Republican convention in Rio Doce that year. And he didn't want to have his name paid for by Mr. Ness on the billboard. So they created this group, Private Persons of New Mexico. And that's where we get into it. But
what information do you have that Mr. Ness had any contact with the campaign, had indicated anybody that was going to do anything about a billboard or anything else before these novel youth, I think it was somebody named Sam that gets credit for this, prepared these images, and on these images, at the time they were prepared, it had the disclaimer on it before Mr. Ness ever entered the picture, as far as I can tell.
Well, I believe that this group of people, whom I believe are Republicans, who were basically clandestinely supporting Ms. Bedonie, didn't want to rock the boat with the Republican Party. And so they decided to call themselves Private Persons of New Mexico. But Mr. Ness has not disclosed who all was in Private Persons of New Mexico.
All right, let me, I should have mentioned this before, Ms. Holmes, but when you're opposing a motion for summary judgment, it's not sufficient to rely on arguments or what you think the evidence might be. You've got to submit something that supports your position by way of an affidavit or deposition testimony. You can't just say, as you did, so-and-so testified at the deposition and then not provide the transcript so I can see that it's admissible evidence that supports your position. So you put me at a disadvantage by not doing that. And
well, your part of the problem, Your Honor, was we had taken the depositions, but we did not have them back yet. So I could not cite the I could only say that they testified in their deposition on February 5 because I did not have the transcripts back yet to provide the reference.
All
But I
right.
did provide reference on the points that I did have depositions for.
I'll give you a pass on this one, and I'll take it based on your representation that's what the witnesses testified. But in the future, if you need more time so that you get a transcript and actually reference the testimony, you need to request additional time for that purpose. Okay.
Yes, Your Honor. Well, just that we believe there are facts in dispute, material facts in dispute, obviously. The testimony of Mr. Raybould is quite adamant.
Well, once again, Ms. Hunt, you can't just say we believe there are facts in dispute. The intervener has listed, I think, 52 facts, specific facts, and I don't know that you even responded to most of them. You responded to some of them, but if you don't respond to them, then can't I assume that you don't disagree with them?
Well, Your Honor, we disagree with all of their points.
Well, that's not true because I just went over 3 of them that you said you agreed with.
Well,
30, 31, and 32.
Okay. Yep, but okay, I'm confused on that. Sorry, Your Honor.
Okay, anything else?
No, Your Honor, I don't believe so. Just that we believe that the facts don't bear out that there was some coordinated effort or that they worked in concert and to put up this billboard and then hide the, and we're talking about less than $10,000 expense, Your Honor. And here we are. But my client did put up billboards in Albuquerque with the picture that she wanted. And if she'd have wanted to put up a billboard with Mr. Ness, she would have even picked the image or picked the place but none of that. Mr. Ness did it all. On the other, our position is that Ms. Bedonie was the special guest and that there weren't in-kind contributions or coordinated expenditures. She was contacted by Mr. Carter to be the special guest.
Okay. All right. Any rebuttal, Ms. Randall?
Yes, Your Honor, if I may briefly. One, I'll start by saying Ness's deposition on page 73, which was provided to the court in our summary judgment motion, he indicates that it was actually Ms. Mavis's idea to put the disclaimer on the advertisement. To Your Honor, I want to circle back to the questioning Your Honor presented to me regarding the coordinated expenditures and whether the relevance or the weight should be given about whose idea it was. And I want to just point out the policy behind why coordinated expenditures has a separate rule from independent expenditures, and that's to prevent candidates from circumventing contribution limits by just saying, hey, gee, wouldn't it be great if I throw these images out here and you all create billboards out of them, and thereby circumventing contribution limits by doing so. That's why they have to report a coordinated expenditure. They provided the graphic and they created the billboard. The last thing I would say is that I would go back to the canva.com image that I provided from May 27th from karenbedonie@gmail.com. It says we designed this graphic using canva.com, not some grassroots supporters created this image from canva.com and gave it to us on our Facebook. It says we created it, whether that was the statement of Ms. Bedonie herself or the daughter, it's a statement of the campaign. I think, Your Honor, if you'll indulge. Yes, Judge?
Go ahead. I'm sorry.
Oh, I'm sorry. I think that Ms. Hans has failed to respond to the summary judgment motions as required by law. She makes bare contentions and assertions that there are disputes, but nothing in the record to support those assertions whatsoever. I think also in this conversation, she makes at issue text messages and communications between Ms. Bedonie and Mr. Ness after the complaint was filed, because she brings up to you during her response that these conversations were in an unmasked text message. She didn't know who she was communicating with. And so she had no ability to go back and provide text messages when sought on a lawful order for requests for production or interrogatories as early as September 15th of 2022.
I'm saying you didn't have.
Go ahead, Mr. Thoughts, did you want to respond to that?
I'm sorry. I unmuted myself and I shouldn't have. I'm sorry. Go ahead.
Okay, all right, so.
I would like to share my screen briefly and show text message where Ms. Bedonie and her husband share with Mr. Ness. They went and purchased some socks from Ness Farms and are sharing with Mr. Ness pictures of him wearing her socks, which again demonstrates their relationship. Here they are texting. This is again discussing Brett Kokinadis July 30th, trying to figure out how Mr. Kokinadis was aware of these billboards and their communications. But more important, on Wednesday, August 3rd.
That's August 3rd, 2022.
Yes, Judge. And here at the bottom, she sends him multiple shots of her husband wearing Ness Farms socks.
Okay, but isn't that again a post-complaint?
Awesome, looking good. Yes, it is, Your Honor, but I'm bringing to the court's attention that Ms. Hans made at issue communications post-complaint being filed just now in her response by saying, oh, well, Ms. Bedonie, didn't know who she was texting to when she was sending group supporter text messages, through iMessage or other means of communication. She knew exactly who she was texting with, her supporter, Stephen Ness, who they coordinated an expenditure with.
Okay.
And so again, Your Honor, I think that the evidence, the uncontroverted, undisputed facts demonstrate that the parties coordinated this billboard expenditure. It is not analogous to an independent expenditure had somebody just screen grabbed it or created it of their own momentum. And it's not analogous to a campaign paying for reporting the cost of yard signs and then distributing them to supporters for in exchange for contributions with the appropriate disclaimer. This is an example of a coordinated effort, regardless of who initiated the coordination and desire to do so. And they failed to report it. And, Ms. Hans touches on that it was less than a $10,000 expenditure, not to belabor this point, but that's, again, a demonstration of the willfulness and unconcerned aspect of taking this process seriously and taking campaign contribution limits seriously. Circling back really quickly, Your Honor, to the second summary judgment motion, which gets not as much attention. It's very clear that, if you look at the checks that were provided in evidence in support of our summary judgment motion, the memo line for every single check is Bedonie for NM. So as far as the people who participated, attended this dinner dance, they were there in attendance as a campaign fundraiser for Ms. Bedonie. Ms. Bedonie enjoyed the fruits of the labor of Mr. Carter, who coordinated with Ms. Mavis once again in putting this fundraiser together, and she failed to report the in-kind contributions of $9,300, which was the cost of putting on the food, the banquet, the tables, the lighting, but also Mr. Kobe Carter and Mr. Will Bannister, who in their own right, are successful local musicians and donated their time and their performance. And for those reasons, Your Honor, I respectfully request that you grant both summary judgment motions.
All right. Okay. I'm going to be out of town majority of this week, but I'll try to get you something within the next 2 weeks. And in the event that I deny one or both of the motions, we'll have our hearing on May 13th and May 14th. And as I mentioned during our pretrial conference, the council need to exchange exhibit and witness lists by April 23rd. And council need to exchange exhibit notebooks and provide me with 2 copies of your exhibits by May 6th. With respect to depositions. If the parties ultimately agree to submit a deposition, you also need to make sure you've discussed whether or not the exhibits that were referenced in the deposition can be admitted, as well as the testimony, so there's not any dispute about that at the time of the hearing. All right, anything else on behalf of the intervener, Ms. Randall?
Nothing further, Your Honor. Thank you.
Mr. Hunts? Ms. Hunts, I'm sorry.
Well, Your Honor, now that we have the depositions, we would like to submit them for the court to read them before making a decision.
What depositions are you talking about?
The depositions that were taken on February 5th of Mr. David Raybould, Ms. Karen Bedonie, and Ms. Crystal Mavis.
Well, you just told me a little bit ago that you referenced what you thought the relevant testimony was in your response, even though you didn't have depositions and couldn't provide specific references to the testimony. And I said, I will accept your representations as true.
Okay.
You don't submit the deposition testimony.
And okay, Your Honor, that's fine. We now have the depositions, so that's all.
All right. Okay, we'll be in recess. And,
Your Honor.
yes.
One last thing. I wanted to just alert you so that you're not surprised by this. After the deposition of David Raybould concluded, he sent an email to both me and Ms. Hans saying that he might need to change some of his testimony based on further review of his, I think, either emails or text messages. And, we didn't bring that in front of the court as an issue because I don't think that anything Mr. Raybould has to say bears on the issues in terms of summary judgment. But if the court enters an order denying the motions, I will probably seek to subpoena those communications from Mr. Raybould, and I may be putting those in front of the court in preparation of the hearing. Just so you're aware, there may be some additional evidence that whatever we get from Mr. Raybould on that.
Was Mr. Raybould advised of his right to review and sign the deposition to make any corrections?
Yeah.
Yes.
And did he elect to do so?
He said he was working on it, and we need to essentially circle back with him and follow up.
And the 30 days, I assume, has passed.
But Your Honor, I'm talking about subpoenaing the communications he referenced. I don't have any basis to question his deposition testimony, but if he's reporting that he has communications that he's been reviewing, I'm going to subpoena those for a hearing, and that would be some additional evidence.
Well, why don't you, if you want to, go ahead and subpoena them, and we'll take up whether or not they're admissible at the time of the hearing.
I just wanted to flag this for you now so that it doesn't look like we've reopened the investigation or something like that. It has to do with his statements after his deposition.
So
Okay,
there was nothing in the summary judgment motions, Your Honor, that they weren't relevant for the purpose of the summary judgment motion.
Well, how did Mr. Raybould let you, when and how did he let you know that you said he sent a text or an email?
He sent an email about a few days after his deposition and said, hey, now that I've gone back and looked through some materials, I might want to change. I think I want to modify what I said. And we said, okay, could you give us those? And then he said he was going on vacation. And then we haven't really followed up again because we had these summary judgment motions before the court.
And I was copied on the email, and I'm also wanting to know what that information is. So.
Well, whatever Mr. Boyd gets, I'm sure he'll provide you with a copy of it.
Yeah, I will, for sure.
All right, we'll be in recess.
Thank you, Judge.
Thank you, Your Honor.
The recording has stopped.